Good afternoon, everybody. Today we're going to have another discussion about EB-5. And in fact, I wanted to talk about one of the biggest problems that EB-5 investors encounter. And a lot of attorneys don't tell their clients about this or don't tell potential investors about these issues until it's possibly too late. Welcome again, everybody. My name's Charles Raether, where for more than 15 years we've been helping investors, entrepreneurs, and other people such as yourself successfully and comfortably plot their transition to the U.S. using the EB-5 program, as well as other visa options. So today I wanted to talk about a situation that we are increasingly seeing in cases that we're filing where USCIS is pushing back, issuing RFEs, requests for evidence, and otherwise challenging certain aspects of the case. And the interesting thing is, this happens even with clients who are coming from countries that have very good approval rates. So it could be, maybe Western European countries, maybe Canada, countries that are, considered, OECD, economically well-developed, et cetera, that you would think, hey, there's really not going to be any problem. It's a country where they have very strict tax requirements. It's very difficult to operate with a cash economy, receive payments under the table, stuff like that. And so a lot of these investors are already confident when they come to us saying, hey, everything is above board, no problem. In particular, we notice this a lot with our investors who have been in the US for a long time. So it could be somebody here who's been in an H-1B so for 5 years, maybe 10 years or longer. Maybe their whole working career has been here in the US, and all the money that they've earned, including the money they're planning to allocate for the EB-5, was earned here in the US. So they have their, their W-2 income, they've got their 1040 tax returns, they have their bank statements, they have their brokerage statements from Robinhood and stuff like that. And many times we share the sentiment that there really shouldn't be any problems. But there is one problem lurking under the surface. That issue we're talking about is the issue of what's called commingled funds. So commingled funds is a term of art that lawyers throw around in the EB-5 space that basically means what it says, that when you have money in one account that's commingled, mixed in from different sources. The simplest and supposedly easiest situation for a client is somebody who's lived and worked in the US for a long time, making a W-2 income, they're earning, $200,000 a year, $250,000, been working here 10 years, they saved up $800,000. Pretty straightforward, they've paid their taxes, they're not hiding any income. It's all above table. But the issue could be is if you've got a checking account that you have in your bank account here in the US, and you receive your salary to that account, but in addition, you're also using that account to, receive, payments back from your friends whom you loaned some money, or you receive payments from, you sold some real estate back in your home country and you got a couple $100,000 back for that. Or let's say your wife had a job, or let's say your wife received an inheritance and that money went into this account. This is where we get into a real quagmire, because when you have significant amounts of funds coming in from different sources and it's all getting commingled with the clean money, we call it the clean money, that you're going to use for the EB-5, the government's going to want to know, where did all this money come from? And so we're going to have to prove, how did your wife get the inheritance? How did you sell that real estate in your home country and you got paid back now for it? How did you earn the money that you gave as a loan to your brother and now he's paying you back? So we're opening up a Pandora's box by using these accounts that have funds coming from various sources. So ideally, what we tell our clients to do is to segregate the money you're going to use for the EB-5. So you create a new account, or you run down the balance down to zero of an existing account, and only after that point do you put in the money there that you're planning to use for the EB-5. Now, you understand, of course, that we can't reverse what's been done in the past. If you've been commingling your funds for the last few years, we can't undo that. I mean, what's done is done. So the challenge in those cases, or the possible solution, is we might have to go through your accounts and source all this other money that's coming in. And that can usually be a difficult task. But if there's not too many other sources of funds coming in, and if they're easily provable, then maybe that's not too difficult. But the other option, which is certainly a safer option and a cleaner option, but it might be more time intensive, is if we say, look, you have too much money mixed in from too many sources here. We just can't source all of this. We can't trace the funds. We're going to kind of have to start anew. And you might open a new bank account where you're going to get your salary going forward. And then you're just going to solely use that account only for your salary, maybe your bonuses, everything related to work, until you accumulate $800,000 and then we go forward with the investment. So obviously the second option, as you can see, is much cleaner from an investment perspective and an immigration perspective, but it does take time. I mean, depending on what your salary is and other factors, who knows, it might take you 6 months to accumulate that $800,000 again. It could even take you longer. Of course, you could also use some other options, maybe get a loan from somebody that has a clean source of funds, maybe a gift. So these are all options we can discuss to come up with a strategy. But if we have to start anew with a fresh bank account, as you can imagine, that might require quite a bit of time, and that might delay the filing. However, having said that, of course, it's always better, I think, to put your best foot forward, even if you have to spend some extra time preparing the source of funds and the path of funds, and you might have to spend 6 months, saving up money in a new account. I think that's generally the better way to go than taking a risk, filing something, and you're not able to prove the source of funds from all these other sources. In any event, hopefully this gives you a little bit insight as to some of these issues and why the EB-5 process can be difficult and expensive, because there are quite a few issues that you have to deal with. Even in cases where you might have been in the US for 10 years earning income and think you have a very straightforward situation. Again, EB-5 is not only sourcing the funds, but it's also tracing the funds, and tracing the movement of the funds and what other funds are in those same accounts can play a very critical role. These are issues you should speak about with any attorney you're considering doing an EB-5 project with. And if they're not able to give you good responses, that's maybe a good sign they might not be a good match for you for your EB-5 petition. Once again, my name is Charles Raether. If you have any further questions, please feel free to reach out to us directly. Leave a like if you thought this video was helpful. Better yet, subscribe to our channel, and we hope to see you in the near future.